Hi everyone, Dave Sugden of Evidence at Trial. Let's talk about one of the challenges that every cross-examining attorney faces, whether it's in deposition or in trial, and that is the non-responsive witness. We've all encountered this witness where no matter how simple our question is, they simply don't want to answer the question that we asked.
How would you describe your image in the media?
How would I describe my image in the media?
Yes.
I wouldn't describe it.
Did you obtain prior approval from the association for that shed?
Actually, I'm assuming you people have gone to the files, the building files, and all the other necessary files. If you haven't, you're a fool. Actually, it was an accommodation that we spoke about, and we never made it. It was an accommodation, and we never made a formal application about it. And if you take exception to it, I'll put it back where it was, which is right on the killer's line. You want me to do that? I'll be glad to. Today, tomorrow, next week, that's where it was. It was on the survey. It's on the survey. And I gently removed it. Am I going to be punished for it? Good. I'll put it back.
Have you ever talked with Selena Gomez and discussed your feelings about paparazzis with her?
Don't ask me about her again.
Sir.
Move on to another. Don't ask me about her again. Don't ask me about her again.
Have you ever?
Don't ask me about her again. Don't ask me about her again.
Wait, let's take a break.
You know what? Just stop.
We gotta take a break.
Did you ever tell any officers at your house on May 21, 2016 that Johnny Depp had ever done anything wrong to you, that night or before?
You're asking me if I've told them?
If you told them on May 21, yes.
Again, I said to them, I decline to give any statement at this time, as per the advice of my counsel. They did make a comment to me about it seeming unsafe. That's why they needed to check the apartment. They made a gesture to my face. They said that I looked hurt. They also pulled me aside and said, look, just say a statement. We can make sure you're safe. Just say a statement or give us a statement and we'll go get the guy. And they said the exact same thing to Josh.
How do we address this? What often happens is one of two things. One is lawyers will start to just bicker with the witness. And all of a sudden, it becomes not a question and answer session, but a sort of petty argument section. And we saw that in some of those video clips where the lawyer starts arguing with the witness. And remember, whether we're in deposition or in trial, we're never arguing with the witness. What we are doing is we are arguing our case to the jury or judge through the witness. That's the first mistake lawyers often make. The second thing, and this comes up in trial, is going to the judge for help too early. What we see in textbooks is when you have a witness that doesn't answer a question responsively, what we're told to do is go seek help from the judge. And specifically, we're told to say, Your Honor, motion to strike is non-responsive, request for admonition. And let me suggest that's bad advice for a couple reasons. Number one, what does that mean to a jury? It's a lot of inside baseball. When you say, Your Honor, motion to strike is non-responsive, request for admonition, it's a huge mouthful, and the jury doesn't exactly know what's going on. The second, and this is even more dangerous, is we're instructed to make that request to the judge with the expectation that the judge is hanging on every word we're saying, will then go to the witness and say, answer the question that was just asked by Mr. Sugden. But that doesn't always happen. We can't assume that the judge is hanging on every word. In fact, judges are often multitasking during trial, and so if you make this motion to strike or ask for an admonition, there's a chance the judge may not recall your question and just say, Mr. Sugden, you got an answer, move on. And now what do? You didn't even get the answer and you're told to move on. So what's a better way to handle this? When you have a witness that's not being responsive, should not be a source of frustration. This should be something that is an opportunity. Because what you have is a witness that's biased. You have a witness that's being an advocate, being more of a partisan than someone who's actually credible. And so what you want to do is use that witness and make a huge opportunity out of it and expose that witness to the jury so they understand what's going on. Let's use a very simple hypothetical. Let's assume you want to ask the witness a question, do you own a car? Very simple question. And instead, when you ask that question, the answer you get is non-responsive. And so you ask, do you own a car? And the witness says, I don't even like to drive. In fact, I prefer Uber, or sometimes I prefer to take a Lyft, or if I'm at the airport, I don't even like to do ride sharing or Uber or Lyft. What I prefer to do is get a taxi. And this answer goes on and on and on, never getting the answer to the question whether or not the witness owns a car. So what do? We don't go to the judge. What we do is we ask the same question verbatim. And what that does is it tells the witness, it tells the jury that we have a witness that's not playing straight. What we have is a witness who's trying to be evasive. And so when you get that long answer, you slow down and ask the same question even slower. You say, do you own a car? And if you get another evasive answer, you then ask the witness, Ms. Witness or Mr. Witness, do you recall my question? My question was, do you own a car? And in trial, you will eventually get an answer because it will be too uncomfortable for the witness to continue to play these games with the jury and judge watching. And what happens when you get the answer, whether it's a yes or a no, even if it's not a big deal in the case, it will feel like one because you've been able to be victorious over this partisan witness who didn't want to give you the answer. And once you've done that once, you can keep doing that exercise. And every time the witness strays and gets an evasive answer and you finally ask the question again, get the answer you want, it seems like a bigger victory than it even is. And so this is an opportunity, shouldn't be a challenge. Very quick, that is how to handle the witness who doesn't want to answer your questions. I hope this was helpful. If it was, please download, rate, review, subscribe to our YouTube channel. If you want to learn more, check out our online courses at evidenceattrial.com. Thanks for watching.